And to Capitol Hill now, the Senate Judiciary Committee announced it will vote next Thursday on its recommendation for the open Supreme Court seat, that timeline paving the way for the entire Senate to vote on Judge Amy Coney Barrett's nomination before the November 3rd election. Senate Republican leader Mitch McConnell says he has the votes right now to confirm Barrett.
Hi. Have I ever talked to you about judicial review and how to reform the United States Supreme Court? On October 5th, 2020, Amy Coney Barrett was confirmed to the United States Supreme Court. The vote in the Senate was 52 to 48, with only one Republican breaking rank and no Democrats voting in favor of her confirmation. The last time no members of the minority party in the Senate voted to confirm a Supreme Court justice was 150 years ago in 1870. To Democrats, her nomination and subsequent confirmation flew in the face of precedent and reflected the increasingly partisan perception of the Supreme Court. Omissions by Coney Barrett of attendance at anti-abortion group meetings while a professor and her consistent dodging of questions related to contested issues during her hearing only strengthened this conception.
Do you agree with Justice Scalia's view that Roe was wrongly decided?
Senator, I completely understand why you are asking the question, but again, I can't pre-commit or say, yes, I'm going in with some agenda, because I'm not.
To Republicans, Democrats were throwing a tantrum over a now solidly conservative Supreme Court and were destroying political decorum in the process. The reason this appointment matters so much is largely based upon two reasons. The first is that the United States is a common law system. We'll get more into what that means in a bit, but briefly, it means that the gaps in legislation get filled by court decisions with such precedents which get followed like laws. As the Supreme Court is the highest court in the country, they have the ultimate responsibility in establishing these precedents. The second reason is that the Supreme Court is not only the highest appellate court for cases involving interpretations of existing laws, but it also has the power of judicial review. Judicial review means that the Supreme Court has the power to review whether a given law or policy is in violation of the U.S. Constitution. They can review federal, state, and municipal laws, as well as policies made by executive branches at both the federal and state levels for constitutionality and potentially render them invalid. However, this power is not inherently vested in the Supreme Court by the Constitution. In fact, it's actually a power that the Supreme Court gave itself in Marbury v. Madison, a case from 1803. After Thomas Jefferson of the Democratic Republicans Party defeated Federalist John Adams in 1800, Adams was not happy to say the least. His party had also suffered major defeats in congressional races, and he wanted to limit the power of the incoming Jefferson administration. So, Adams rushed through the Midnight Judges Act, also known as the Judiciary Act of 1801, which seriously reformed the federal court system, and 2 days before Jefferson was to take office, Adams appointed several Federalist Party loyalists to new judge positions and had the Senate quickly confirm them. However, not all of their commissions were delivered before Jefferson became president, and once he took office, his new Secretary of State, James Madison, refused to deliver any outstanding ones because that administration saw them as illegitimate. One of these Federalist loyalists, William Marbury, sued Madison in the Supreme Court, asking for a writ of mandamus, essentially a court order, mandating that Madison deliver him his judgeship. The court ended up ruling against Marbury, but on a technicality. Adams appointed Chief Justice John Marshall authored the majority opinion that the president is not above the law, Madison's refusal to deliver the commission to Marbury was illegal, and, under normal circumstances, a writ of mandamus would be the appropriate response. However, Marshall also knew that this was a new country, and were he just to mandate the new President Jefferson to deliver the commissions, he would just ignore the order, as the Supreme Court has no way of enforcing its rulings. So, in order to preserve the legitimacy of the court, he had to find another conclusion. The latter part of his ruling, and where it turns against Marbury, is that, according to the Constitution, this case doesn't fall under the Supreme Court's original jurisdiction, meaning that this case could only be brought to the Supreme Court via appealing decisions in lower courts and not straight to the Supreme Court. This established judicial review because the aforementioned Midnight Judges Act expanded the scope of the Supreme Court's original jurisdiction. Marshall ruled that the Constitution is the supreme law of the land, and thus any conflicting laws passed by Congress are negated. Examples of more recent high-profile cases where this has been implemented are Roe v. Wade, which held that many federal and state laws that limited access to abortion violated the Due Process Clause of the 14th Amendment, Loving v. Virginia, which ruled that laws banning interracial marriage violated the Due Process and Equal Protection Clauses of the 14th Amendment, and Obergefell v. Hodges, which found that laws prohibiting same-sex marriage also violated those same two clauses of the 14th. Because the immense polarization of the Supreme Court and the hyper-partisan public image of an institution meant to be seen as apolitical, I wanted to examine the role of judicial review in other countries and see what the structure and public image of the highest court in those countries looks like. I want to see if anyone's doing better and if there's any realistic prospect for reform that could improve our system. To do this, I limited my search to other federal democracies to limit the amount of impact that national structural disparities could have on the court system. So today we'll be looking at 3 other countries: Australia, Spain, and Germany. But first, let's look at the structure of our own Supreme Court. The Supreme Court of the United States is currently made up of 9 justices, though it's been as little as 5 and as many as 10 throughout time, but it's been this size since 1869. Justices are nominated by the President and confirmed by a simple majority in the Senate. They serve for life or until retirement, but many do literally hold this position until they die. It also has a fairly wide scope. Its original jurisdiction is infinitesimally small, but it serves as the highest appellate court for any case involving federal law or constitutionality. It also possesses judicial review, but as we just talked about, it only has it in practice and it's not technically granted in the Constitution. They also only hear about 100 to 150 cases per year, and they get to choose which they hear out of over 7,000 per year which reach them. They are widely seen as pretty partisan, and this is because the Senate and presidency often align in party, and due to the rigid 2-party system in America, a simple majority is an easy task for the ruling party. Their relatively small number and lifetime appointment also gives their nomination extra urgency, as their tenure frequently spans multiple decades. They're also allowed to accept outside gifts, some literally receiving all expenses paid for vacations, which has raised some questions around the preservation of impartiality. Alright, mate, so the first country we're looking at today is Australia. Like the United States and many other former British colonies, Australia uses a common law system. This means that judicial decisions are binding, and at the level of the highest court, judicial decisions can only be overturned by legislation or the same court. Generally, things not expressly prohibited by law are permitted, but these gaps can also be filled by judges issuing decisions that interpret existing laws of the Constitution that serve essentially as another layer of legislation. Australia's structure is that of 6 states united under one Commonwealth. The responsibilities of each level are outlined in pretty decent detail in their constitution. However, the framers of their constitution intentionally left overlap. Like in the US, in cases of overlap, the federal government takes precedent. Also like the US, the federal government has increased its power over time by increasing regulation on services that states are tasked with providing, increasing the amount of conditions placed on grants, and also just straight up overriding state legislation. The High Court of Australia is, as the name suggests, their highest court. It is made up of 7 justices and 1 Chief Justice, which are nominated by the Prime Minister and confirmed by the Governor-General, which is a representative of the British monarchy. Their confirmation is generally ceremonial, so it's essentially the Prime Minister's choice. The appointment is for life, but justices must retire at the age of 70. The High Court, like the Supreme Court of the United States, can only act once a law is enacted. However, it has a lot more original jurisdiction. Suits involving state and/or federal governments, as well as the Constitution and laws passed, can be brought straight to the High Court. It only serves as the highest appellate court when the case is of significant public importance or lower courts reach differing rulings. And the justices of the High Court get to choose which appeal cases they hear. Also like the US, judicial review as a vested power of the High Court is disputed by scholars, but nonetheless, the rulings are seen as valid and binding. Their rulings involving judicial review tend to involve disputes of domain between a state and the federal government. Despite the unilateral nature of their appointment by the ruling party, the High Court is generally seen as a nonpartisan institution. The only bias in recent decades has been a drift towards a more unitary model, which in Australian politics is less partisan and more the interest of whichever party is in power. This, in recent years, has hurt the public image of the courts, as Aussie citizens, unlike the parties, tend to prefer a weaker federal government, though some recent decisions have halted the power creep of the federal executive branch, which may represent a new equilibrium having been found. However, Australia has also been called constitutionally frozen, which can serve to bolster the court's power. Only 8 out of 44 proposed amendments to the Constitution have passed in Australia because they need to pass a majority in both legislative bodies, a majority of the citizens vote nationally, and a majority of the citizens vote in the majority of the states. This tedious process to alter the text that the High Court bases their decisions upon could cause anti-High Court sentiment to continue to rise if the trend towards a more unitary system continues. Hola, buenas tardes, ¿qué tal? Y vamos a hablar sobre España y su tribunal constitucional. Alright, so the first major difference between Spain's system and the United States is that Spain is a civil law country. That means there's a written constitution and laws that enshrine responsibilities and rights. Things not covered by this legislation doesn't necessarily mean you have that right, and oftentimes a court case involving that will prompt a legislature to pass a law covering that area. These systems tend to involve a higher volume of legislation, and that legislation tends to be more prescriptive than in a common law system. Judges serve to evaluate compliance with laws, and in the case of a court that has the power of judicial review, evaluate compliance of those laws with the Constitution.
In Spain, we'll be looking at the Constitutional Court of Spain, also called the Tribunal Constitucional, or the TC. This court is separate from the Supreme Court of Spain, which is the highest appellate court and has original jurisdiction over cases involving government officials and the banning of political parties. The TC, established by the post-Franco Spanish Constitution of 1978, is made up of 12 judges called magistrates, one of whom is chosen to be president of the court by vote of the other magistrates. They serve 9-year terms with no chance for re-election and must have 15 years of relevant experience, working as a judge, lawyer, or law professor, for example, in order to be nominated. The process for nomination is a bit unconventional. 4 magistrates are chosen by each of Spain's 2 legislative bodies, 2 are chosen by the Prime Minister, and the remaining 2 are chosen by the outgoing magistrates. Most of the cases that the TC hears deals with conflicts of powers between the federal government and the autonomous communities of Spain, their version of states. These cases are brought by government officials or autonomous communities' governments. A citizen may bring a suit to the court only in the case of negative conflict, which means that the government failed to act somewhere that they were constitutionally bound to. Though the TC is a relatively new institution, it had largely captured the faith of the public as a fair, nonpartisan institution for most of its existence, that is, until a little over a decade ago. In the mid to late 2000s, the autonomous communities were given the chance to revise their statutes of autonomy, which are essentially their individual constitutions. 2 of these revised documents were met with legal challenges. The first was relatively minor. Valencia's new statute was written and passed with little issue, but 2 autonomous communities ended up challenging a passage which codified the right to water resources and the transfer of excess water from other basins, which they took as Valencia claiming right to resources that were not theirs. Their legal challenge ended up being unsuccessful. However, a subsequent huge challenge was imminent. Catalonia's new statute of autonomy was largely seen as the model statute, expanding their judiciary and enshrining a list of basic rights. It also contained a lot of references to the separate Catalan culture and history, and, as would be the biggest symbol of its downfall, a reference to Catalonia as a nation. The Unitarian centre-right People's Party was a minority in the Catalonian legislature, and thus resorted to challenging the new statute in the Constitutional Court after it passed in both the Catalonian and Spanish parliaments and by referendum in Catalonia in 2006. In total, the People's Party challenged 136 provisions of the 223 articles in the statute. After a long period of deliberation, in 2010, the magistrates of the Constitutional Court struck down a significant number of reforms, many on small technicalities, and the window for revising statutes was closed, leaving Catalonia behind the 16 other autonomous communities. Additionally, the magistrates' rulings were generally highly contested, with provisions being struck down only by a vote or 2. This angered many Catalonians, as the court was only operating with 10 out of the usual 12 magistrates. One had passed away without their seat being filled, and another was pressured into recusing himself due to his ties with Catalonian nationalists. This meant that, were the court operating at full capacity as per normal, a significant amount of the passages struck might have been kept.
What had previously kept the balance had become an intensely polarizing institution. Though it's been a decade since this court ruling, a lot of people who supported the new Catalonian Statute of Autonomy don't have the same faith in the Constitutional Court as the impartial institution they once thought it was. However, because of the short term length, the mistrust created by those magistrates does have a way of fading faster, as no one who was on that court is still there. Additionally, because the Constitutional Court only has the power to strike down laws and not effectively legislate with their decisions, this mistrust doesn't have the same ramifications for the political process as it would in a system like America or Australia. Guten Tag. Welcome to Deutschland. Alright, so finally, let's talk about the Federal Constitutional Court of Germany. This one does so much right, and I'm really excited to talk about why.
So first, the basic structure. The Federal Constitutional Court, or the FCC, is made up of 16 justices, which are split evenly into 2 senates. Most are law professors, however at least 3/8 of the FCC must have served as federal judges. Like Spain's Constitutional Court, the FCC is purely a constitutional court, separate from Germany's highest court, the Federal Court of Justice. These justices serve 12-year terms, cannot be re-elected, and must retire at the age of 68, even if that's before their 12 years are up. They're elected by a 2/3 supermajority in one of the 2 legislative bodies, which take turns picking justices. Informally, the 2 major parties also take turns in selecting justices, but the need to acquire a 2/3 majority generally keeps the partisanship low and the professionalism high. The scope of the cases the FCC can see is very high for a constitutional court. Cases that fit into its original jurisdiction can be brought by the federal government, land, aka state governments, or 1/3 of one of the two legislative bodies. Lower courts can also send cases up to the FCC if they think it involves a constitutional issue, and citizens can appeal cases up to it if they think their basic constitutional rights are being violated. This last group accounts for 97% of the court's cases, but are successful less than 2% of the time. The FCC can also be asked by a governmental branch to review a law before it's enacted to evaluate constitutionality and thus identify areas to modify if need be. Because of the method for their nomination, the court is not very partisan between parties. In recent years, though, the court has drifted slightly more towards bolstering the power of land governments, but that's not too much of a major trend. The high rate of professionalism in this court is reflected by the fact that since 1971, 93% of their decisions have been unanimous. Accordingly, the public have immense faith in the impartiality and quality of their rulings. This is also because, unlike the Supreme Court of the United States, the FCC rulings are not very final. The most common outcome of a judicial review decision by the FCC is an amendment to the Constitution, sometimes in accordance with its guidance and other times overruling the constraining parts of the Constitution. There's a constant interplay between the FCC and legislators that ensures a strong sense of legalism in Germany's laws, even amongst the variants created by a federalist system.
What strikes me most about Amy Coney Barrett's confirmation is that in any of these countries we talked about, it would be such a highly different process. In Australia, there wouldn't have been any hearings. The Prime Minister just gets to ceremoniously nominate her and then she gets pretty much instantly confirmed. And in Germany, she wouldn't even been nominated. The need for 2/3 of the legislators to vote for her would have made someone who's perceived as partisan as her just a non-starter. What fascinates me most, though, is that in the civil law countries that we looked at today, the structure of the judiciary and how the judges are picked and nominated and confirmed actually makes the courts more democratic than in the common law systems where they have more impact. The shorter term length that judges have in Spain and Germany allows the courts to be more reflective of political currents in the people. It also allows an effect for the courts to be more democratized, because if one party is confirming a lot of judges that the people do not agree with, when their time runs out, they can vote for another party who would get to confirm their successors. This more consistent and more frequent window makes the courts a lot more democratic, which I think would be of a higher necessity in common law systems rather than civil law. Additionally, you can see in places like Australia and America, where the highest court has lost a lot of the faith of the public, those tenures last a very long time, so the people who are making those decisions that ruin the faith stay on there for a long time. However, in places we talked about, like in Spain, where they did lose a lot of faith of the public after the ruling on the Catalonian Statute of Autonomy, no judges who made that decision are still on the court. All of those magistrates have had their term ended and new ones have replaced them. This consistent cycle of turnover allows for faith to be restored if there's a bunch of magistrates or judges or whatever the country calls them who are making decisions that go against the will of the people. Meanwhile, in the United States, the fact that a justice can be confirmed when they're 40 and serve till they're 80, 90, or whenever just makes it so that if they're making decisions that make people mad, the people have to live with it. There's not really any change that can be done. And personally, I think we really do need to bring a lot of those systems that they have in Germany and in Spain in to help restore the faith of the people in the courts and keep it with a lot of faith in the courts. Given that it's such a powerful institution in our system, we need to make sure that the people believe in it and want to uphold its rulings, especially when it has no ability to enforce it on its own. Realistic prospects for reform for the Supreme Court could be 18-year term lengths where each justice is offset by 2 years, no chance of re-election, and that way each president for each term gets to pick 2 justices, and that way the people have a consistent window in which they get to give feedback on the court. Additionally, though it may be harder to get passed through the Senate for obvious reasons because no party would want to cede this power, maybe you make the confirmation require a 2/3 majority. Though some may worry we may lose out on justices that we would see as champions of human and civil rights, a lot of the justices that people really like in the court currently were confirmed by huge majorities. It's only more recent polarized picks that have really just split down party lines. Given the importance that the Supreme Court has in our common law system, it's important that we restore its image of integrity for people of both parties. I think we need to reinforce the integrity of the Supreme Court, and these reforms could do so by making the decisions and justices more reflective of the electorate and helping restore its more nonpartisan image.
Alright, I'm new to this, so I forgot to record an outro, but if you like this video, leave a like, subscribe, leave a comment, and yeah, thank you. I'll see you next time.